Good morning and welcome to this HR Advanced webinar where we're tackling the topic of long service leave. I'm Alison Williams, Managing Editor at HR Advanced, and with me today is our own IR expert, Paul Munro, who has a lifetime of experience in answering employers' questions on just this sort of complex topic. Welcome, Paul.
Hi, Alison. Hi, everybody.
Now, I'm not going to waste too much time on an introduction because we have a lot of questions to get through, but I do want everyone to know that because this is such a popular topic, we're considering running another webinar early next year, exploring a different set of issues. So I would just ask you to stay online at the end of the webinar and give us your feedback as to whether this is something that might interest you. So, the first thing we're going to do is we're just going to run a poll to see what state or territory that you are located in. Okay, great. Thank you for that. So let's get started with our first scenario. Well, that's me and Paul. Already met us. Let's go into it. Okay, question one. So the scenario is the company has an employee who is absent on 2 months long service leave. The employee is employed in their Sydney office and has been diagnosed with a serious illness. The employee was admitted for treatment and will remain in hospital for approximately 3 weeks. His immediate manager has contacted the family, who indicated the employee would not be fit to return to work for another 2 months. The employee has already been absent on long service leave for 3 weeks, so their question relates to the employee's entitlement to personal carers leave while they're already absent on long service leave. Are they able to claim personal carers leave for the period of their illness and have the equivalent long service leave recredited to their long service leave accrual? And also, the period of the absent could possibly cover the Christmas, New Year period. So would the public holidays that fall in that period extend the period of long service leave? So Paul, over to you.
Thanks, Alison. I guess before I answer the questions, I guess I should put some sort of presumptions in these answers. Some of the questions that have already come through are asking about particular sectors such as the building and construction industry. Today's questions and answers only relate to state and territory long service leave legislation. There are any number of different sources of, as much as that covers the majority of employees in Australia, the number of sources of entitlement to long service leave can be industry specific. I'm hopeful that if you are operating in an industry where there is industry specific long service leave provisions, that you're already aware of them, bearing in mind that there is, I guess, a hangover from the pre-Fair Work days with award-derived long service leave terms, which were long service leave terms that were in previous federal awards, and they are preserved by the National Employment Standards. So today's webinar doesn't specifically cover those, once again because each award is different or can be different, much the same as each state and territory legislation can be slightly different depending on the particular circumstance. The other thing is that the cleaning industry and the community services sector in some jurisdictions in some states and territories also have payment-related long service leave provisions as well. So hopefully if you are operating in those sectors that you are aware of those as well. But moving on to answering this particular question, generally with personal leave, the answer is no. Unfortunately, it's one of those things. The employer is not obliged to extend a period of long service leave if someone is ill. Likewise, if someone is caring for somebody, in other words, if somebody is entitled to paid personal carers leave, there's no real requirement to extend the leave. Of course, the employer can do so if they so wish, but that's not something that the employer is required to do or legally obliged to do. So in all of the jurisdictions, none of the acts refer to specifically the circumstance. So it's presumed that because it is silent on it, that it doesn't extend it. So that's always been the way that the legislation has been interpreted. So that's the situation, not just in New South Wales under the New South Wales legislation, which applies in this particular scenario, but that would apply in every circumstance throughout the country. Public holidays is slightly different. There's a reference there to the upcoming Christmas and New Year public holidays. There is state and territory legislation once again, which long service leave legislation, which can differ on this point. So, for example, in New South Wales, in this particular jurisdiction, the long service leave is extended by 1 day, or for every public holiday that occurs. Likewise, it's the same in places such as Queensland, whereas in Victoria, for example, it doesn't extend the long service leave, nor in South Australia, whereas in the ACT it is extended, and it also is extended in Western Australia. So the situation with public holidays is different. In fact, it's probably the only period or type of paid leave that extends long service leave in certain jurisdictions. Likewise with with annual leave, or for something like such as compassionate leave, if someone's relative dies while they're on long service leave, once again the compassionate leave is absorbed into the period of long service leave. Likewise, it's implied or it's presumed that a person can't take annual leave during the same period of long service leave, that they are mutually separate entitlements and for two separate reasons. Therefore, the entitlement to annual leave is a separate entitlement to long service leave and cannot be taken concurrently with a period of long service leave.
Okay, thank you, Paul. That's the bottom line.
So yes, mostly, certainly with personal carers leave or with any other forms of paid leave, it's not extended, but public holidays, it depends on the jurisdiction.
All right, we'll move on now to our next question. We're going to try and get through these as quickly as we can because we do have a lot of questions that have been submitted by people as well. Okay, does long service leave continue if the employee is re-employed? So in this scenario, we have an employee who was employed under a previous contract of employment from September 2010 until the end of August 2015 when her employment was terminated. But she was then re-employed later in that year from October 2015, and her current contract is ending at the end of December this year. So her current contract makes no reference to recognising previous service with the company for the purpose of long service leave, and she is asked whether she'll be entitled to pro rata long service leave on termination as she's completed over 7 years total service with the company. Now, our view is that because there was a break in service between the two separate contracts of employment, she does not qualify for payment on termination, as her leave would be calculated from the commencement of the second contract of employment. So the employee is employed in Queensland. So, Paul, what do you think?
Well, once again, it's subject to what the Industrial Relations Act actually is the source of an entitlement to long service leave in Queensland. The break here is approximately 2 months. The important thing under Queensland legislation is that that continuity is not broken if the employee's employment is terminated by the employer or the employee, and the employer re-employs the employee within 3 months. So 3 months is the magic figure there. Interestingly too, the important point here is that it doesn't matter who terminates the employment, whether it's terminated by the employer or the employee. So that's an important consideration as well, because that's something in other jurisdictions which there can be a difference. The employee may not necessarily have an entitlement if they resign of their own accord. So the previous service would count, but not the period in between the contracts. In other words, the break in between the two contracts wouldn't count as service, but previous service would count up until the original termination, and then it would recommence at the date of re-employment of the employee. In mentioning the other jurisdictions, it's important to determine who terminated the contract, or maybe it's important to determine who terminated the contract of employment, and then also consider the period of re-employment. For example, in New South Wales, it only applies, or previous service is only recognised if the termination is by the employer and they're re-employed within 2 months. Whereas same with Victoria, except the previous service counts if the employee is terminated by the employer and they're re-employed within 3 months. So you could have an employee in New South Wales where they're under a new contract after 2.5 months. Previous service would not count, whereas if it happened in Victoria, then the long service leave, the previous service would count towards the total accrual of long service leave. The same circumstance applies in Western Australia, except it's 2 months there if they're terminated by the employer, and likewise in South Australia, it's by the employer and re-employed within 2 months. And then in Tasmania, it's for any reason, if they're terminated for any reason by the employer, or the employee is terminated for any reason and re-employed within 3 months. So it's one of those things where it's either 2 months or 3 months, depending on the jurisdiction in which the employee operates. So previous service may count. So if you are re-employing somebody, I must admit these provisions were put in to all of the legislation some 30 odd years ago. Generally was probably when the first changes were made, was to recognise casual employment, because the nature of casual employment is where people are terminated and re-engaged. So rather than saying that the Act applies to casual employees, they just structured it so that it recognised service where the nature of casual employment is that if it's 2 or 3 months, then if they're terminated and re-employed within those periods, specified periods, then that's continuity of service. It's just that because of the way that the legislation is worded in each of the states and territories, it catches all employees in all circumstances. So a full-time person, for example, who's terminated and re-employed within, say, 2 or 3 months, depending on the jurisdiction, their previous service would be recognised as well. So once again, it's this will be a very common bottom line, and that is that the state and territory legislation determines whether service counts towards it, and the important thing is whether it's 2 or 3 months, and that infographic there is a very good summary of how it applies in the different jurisdictions.
Thank you, Paul. I feel clear on that one now. Okay, our next question. Is long service leave payable on retirement? So in this scenario, we have an employee who has completed approximately 9.5 years continuous service with our company, and she's indicated she intends to retire from work in a couple of months. Details of the amounts she'll receive from us upon her retirement was sent to her, but the non-payment of accrued long service leave has been questioned by her. The employee was advised by the company that an entitlement to pro-rata long service leave was payable on termination only if she had completed 10 years service with the company, because her retirement was not due to illness or incapacity. Now, our head office is in New South Wales, but this employee is employed in Tasmania. The New South Wales legislation does not appear to provide an entitlement circumstance. So is the employee entitled to payment of long service leave if she's retiring?
If retirement is the sole reason, in other words, the person is giving up work to retire, under Tasmanian legislation, the answer is yes. Whereas under they're quite right in making the statement about the New South Wales legislation. Retirement of itself, someone just retiring because they feel they've reached an age where they no longer need to work, is not a reason for a qualification for that under New South Wales legislation. But under Tasmanian legislation, it's the age of retirement if someone's been there at least 7 years. In the case of an age for retirement as prescribed by the award, well, not many awards. I don't know of any award that prescribes a retirement age as such. It's 65 years in the case of a male under the Tasmanian law, or 60 years in the case of a female. So that's also an important consideration, that if, for example, if someone is a male who is 59 years of age, or a female who's 59 years of age who wants to retire under Tasmanian legislation, they wouldn't qualify because they haven't reached the age that the Act recognises as being the age of retirement. So there's a couple of qualifications there under Tasmanian legislation with respect to retirement. The other thing is that, as I mentioned, retirement, if it's purely to give up work to retire, then that's not a reason of itself that falls under the category of illness or incapacity or domestic or other pressing necessity. It's not regarded as, say, under the other pressing necessity phrasings of the various legislation if there isn't a specific reference to retirement in the state or territory, the relevant state or territory legislation. So, for example, though, if someone is retiring because of ill health, say under the New South Wales legislation, it does talk about if the person is terminating after 5 years because of for reasons due to illness or incapacity or domestic or other pressing necessity. So they would, or someone, for example, has to retire to care for a sick partner, is another circumstance which may be fairly common as people get older, that they may retire to do that. Well, then that is a different situation again. So retirement can be a little bit of a word that can be used in any number of different ways. So you'd need to not just ask the question of are you retiring, you would be best to ask an employee, well, what is the circumstance or the reason by which you are retiring? Otherwise, the employee may very well have an entitlement because they're retiring for reasons which may very well qualify them. So retirement can be a word that can be misleading in those sort of circumstances. For example, I'm just going through looking at some of the other state and territory legislation with respect to retirement. The territory legislation has a reference to retirement, and that's the relevant pension age under Social Security. ACT is the same. It's after 5 years, but it's has where the person's remaining the minimum retirement age, which in other circumstances is 65 years of age. So 65 still seems to be the age that a lot of this legislation refers to. Just looking at some of the other pieces of legislation, some of them, or most of them, or like for Victoria, for example, and South Australia and Western Australia, you get it regardless of the reason for termination. So if someone is terminating their employment, the reason is irrelevant, say, in Victoria or Western Australia or South Australia, because once you reach the qualifying period of 7 years continuous service, then you are entitled to a pro rata payment of long service leave on termination, regardless of the reason for the retirement. Queensland is the same as New South Wales. That is that unless the reason for retirement is due to an illness or incapacity or because of for caring, such as domestic or other pressing necessity, then retirement of itself is not a reason for qualification for pro rata. Once people have qualified, once again, these are the qualifications for pro rata long service leave. Once someone has reached the relevant period, for example, in New South Wales it's 10 years, most states it's 10 years, some states it's 7. Once someone qualifies for long service leave, then there's a payout of pro rata long service leave on termination, once again, regardless of the reason for the termination. So so this is more a circumstance where the person may not be entitled to pro rata long service leave because they haven't actually served enough time to qualify to actually take long service leave.
Okay, thank you, Paul. I was thinking, who knew it was so complicated? And then I thought, it's long service leave. Of course, it's complicated. Okay, so we'll move on to our next question. And this is a pretty common question we see. Can the employer direct an employee to take long service leave? So our scenario in this case is our company is currently suffering from a downturn in trade, although a number of new contracts mean the business will pick up again later in the year. We have 2 long-serving employees who are both eligible to take long service leave. We've advised both of them to apply for leave, and having explained our current predicament, one employee is unwilling to take the leave as he says he's saving it for an overseas trip next year. So are we allowed to direct these employees to take their long service leave, or can it only be taken by mutual agreement? The employees in this case are located in New South Wales.
Yeah, well, it's long service leave is one of those, because the period of time where an employee can be away is so long, Generally, obviously, the ideal situation is that it's done by mutual agreement. The employer can certainly direct an employee to take long service leave where the employee or where agreement can't be reached to actually take the leave within a whatever reasonable period of time. The amount of notice generally required does vary depending on the jurisdiction. 60 days, which is 2 months, is quite common. New South Wales, it's usually 1 month, but generally it's longer. But once again, usually in a lot of the jurisdictions, it's if agreement can't be reached, then the employer can direct the employee to take long service leave. I've certainly found in most of the places where I've been asking or being asked questions on this particular issue, you generally find that mutual agreement works because the employer has obviously a business to run, and you don't want people being able to have the right to take long service leave at any particular time, because the amount of time away is obviously considerably longer. That's why there's still this direction or ability to direct in legislation for long service leave, as opposed to annual leave, which under the Fair Work Act, the employer can't unreasonably refuse a request for annual leave. There is no long service leave legislation that looks at that, although once again, where agreement can't be reached, for example, in Western Australia, then the employer can't refuse a request where agreement can't be reached if it's more than 12 months after the person becomes entitled to the leave. So once again, it's something specific to WA, but in all the other jurisdictions, generally the employer has a right to send people on long service leave, provided the appropriate period of notice is given, which is, as I say, it's a month in New South Wales, but it's 2 months in pretty much most of the other jurisdictions as well. It's 3 months in Victoria, I'm just noticing here. So once again, it's something that changes depending on the state or territory legislation. So, but in answer to the general question of whether an employer has the right, it is different to annual leave, and the employer, if they are of that mind, can send somebody on long service leave once they qualify for it, provided they give the appropriate notice under the relevant state or territory legislation.
Thank you, Paul. I've got another question for you now. It's about cashing out long service leave. That seems to be one of the most popular questions that we've had on this topic. So this employer's question starts as thus. Our company is reviewing our leave policy and currently looking at long service leave. At the moment, the policy prohibits an employee from cashing out long service leave. However, we often do receive requests from employees wishing to do this because they're in financial difficulties or some other sort of circumstance. The policy has not been reviewed since the introduction of the Fair Work Act in January 2010, and we're not sure whether there have been any changes to state and territory long service leave legislation during that time, which may, or since 2010, which may affect the policy. Our company operates in every state and territory except Tasmania. So the question is, would the terms of the company policy, which allows cashing out of long service leave for our employees, contravene any law?
Well, the answer is it could, depending on, once again, which state or territory the employees are employed. This is a common issue as well with companies who are attempting to have enterprise agreements approved before the Fair Work Commission, and if they want to bring in a general term in the terms of the agreement, or bring in a policy, company policy, which allows cashing out in every state and territory in Australia, certainly under enterprise agreements, for example, it wouldn't pass the boot test. The Fair Work Commission already has issued a number of determinations in respect to this, where a company is attempted, for example, in jurisdictions such as New South Wales, where cashing out is not permitted, where it's failed the boot test. So the company would have to revert to the state legislation in that case, which means that cashing out is not allowed. New South Wales as well is interesting in that for those, it's sort of set a precedent case some years ago about a company that cashed out long service leave in New South Wales where it's not permitted. And the New South Wales Industrial Commission determined that in cashing out the leave, the company actually didn't comply with the Act. So, in fact, the employee was still entitled to the same period of long service leave. So the amount of money that the company paid out was a gift or an ex gratia payment. So in thinking that in cashing out you're doing the right thing, and a lot of these days in particular with the cashing out of annual leave, there are a lot of inquiries from employers these days about cashing out long service leave because it's presumed that because you can cash out annual leave, maybe the long service leave terms have been changed as well to reflect that too. But the answer to that is no, not necessarily. There are some jurisdictions, in fact, probably half the jurisdictions in Australia do permit cashing out in various forms or under various circumstances. If, for example, in South Australia, there's you can cash out there. That's if it's by mutual agreement. In Queensland, the employee can make application to the Queensland Industrial Relations Commission for an order to make payment. The order is normally only granted when it's due to compassionate grounds or financial hardship. In fact, financial hardship is probably the main reason why employees approach an employer for cashing out any leave, be it long service leave or indeed annual leave. So financial hardship, as much as the employer may want to help out the employee at that particular circumstance, be aware that if you're in a jurisdiction which does not permit cashing out, then you are liable to still for the amount of leave, even though you think you have paid out that liability. And WA has the same; it allows that, and so does Tasmania. So, for example, in Victoria and New South Wales, you are not permitted to cash out long service leave. The other thing is too, and I'll probably mention it a little bit later. There's the Victorian State Parliament is going to, or has a bill before Parliament which seeks to amend long service leave in Victoria on a number of different things. Interestingly, though, one of the things that the amendment doesn't attempt to introduce is cashing out of leave. So the Victorian government has certainly decided that the Long Service Leave Act in Victoria, if these amendments do go through as proposed, cashing out will still not be an entitlement that Victorian employees will be able to pursue. So that's something that's interesting. Whereas, for example, in the ACT, there was talk down there that they actually were going to introduce like a long service payment, such as operates in the building and construction industry, that would apply to every employee in the ACT. So it's funny how different parliaments have different ideas about what to do with long service leave. And also we get questions about the National Employment Standard, and there's long service leave in that as well. But that's been, for 7 years, there's been discussion about whether to have a standard long service leave term that operates throughout Australia. And as today's webinar highlights, it would probably be an advantage to employers to actually have a standard that applied throughout each jurisdiction. But alas, it certainly doesn't seem to be anything on the horizon. There hasn't been any moves afoot to even have an inquiry into any further inquiry. There's been an inquiry, but no further inquiry into introducing a standard long service leave entitlement under the National Employment Standard. So I'm afraid employers are going to be having to put up with the current system for the foreseeable future.
And it's all just so complicated. Let's have another question, and it's about workers' compensation. In this scenario, an employee who's currently receiving workers' compensation has applied for 2 months long service leave. The employee is not expected to be fit to return to work for at least 3 months. He's requested the long service leave because of financial difficulties living on workers' compensation payments. And he's been employed by the company for approximately 11 years, so he does have an entitlement to take long service leave. While we're sympathetic to his predicament, we are not sure whether he can access paid leave when he's actually absent on workers' comp. So our question is, does the Fair Work Act prevent the employee from accessing his accrued long service leave when he's absent on workers' comp? And also, would the employee accrue long service leave while he's absent on workers' comp? This employee is located in Queensland.
Well, no, the NES wouldn't apply. Once again, the relevant state long service leave legislation would determine whether or not somebody can take can take long service leave while they're absent on workers' compensation. You'll generally find that, in fact, most legislation doesn't particularly refer to it specifically, which means that it's possible to do so, certainly under Queensland law. In the other jurisdictions, I guess the only legislation is in Tasmania, where it states that the employee is not required to take long service leave while absent on workers' compensation. But what exactly that means, not really sure. It seems as if may not be able to take workers' compensation or long service leave when on workers' compensation. But that's the only jurisdiction that mentions it in that particular situation. So. Generally, it's one of the few things where there seems to be some commonality of term amongst the jurisdictions, and that is, unlike with annual leave, it's depending on the workers' compensation legislation. The state and territory long service leave legislation doesn't seem to prohibit someone taking workers' compensation when on long service leave.
Okay, all right. We've got one more question that we had organised to answer, and then we will, if we have time, just address a couple of the questions that have come in. Okay, does overseas service count? This employer is a multinational corporation, and they've offered employment to a colleague who's employed in their London office. He's been employed there for the past 6 years, and it's a related company with the same parent company ownership. They've provided the employee with new Australian employment contract, and he will be working in their Sydney office. So the question is, while there is no fixed period of time as term of the contract, if the employee does remain in their employment for a number of years, would the company then be legally obliged to recognise the prior overseas service with their related company when calculating whether there's an entitlement to long service leave relating to any future termination of his employment?
Yeah, it's one of these questions that is really subject to case law. It's not something that's envisaged in the legislation itself. It just operates within its own particular jurisdiction. Generally speaking, if someone's transferred here on a permanent basis and from an overseas company that is related, then it's more than likely that the previous service will count. Strangely enough, it's not a question that's been subject to a lot of judicial review. The current case law revolves around, once again, New South Wales Industrial Relations Commission's decisions interpreting the New South Wales Long Service Leave Act, which the other states seem to have adopted in terms of the principles espoused in that decision. But basically, there's got to be some substantial connection with the jurisdiction. So the strange thing is substantial doesn't mean majority. So, for example, if someone's been 5 years in Australia or 5 years overseas and 5 years in Australia, that could be even only 2 years in Australia, and the person could still qualify for long service leave. So I guess it depends on the nature of the arrangement. If it's a secondment, probably not. If it's a secondment for a short period of time. So if someone's sent to Australia to work for a short period of time, you generally wouldn't have to worry about it, I wouldn't have thought. The other thing is that the case determined was where the event occurs, and the event that they refer to is either termination or a person being here being employed in total for 10 years by the same or related companies. So it's where that happens as well, which is important. So I've never seen a case where somebody has worked here for 5 years, worked 5 years in a New York office of the same company and claim long service leave. That's probably one that may crop up in the future, but so far that hasn't happened. So it would appear that the termination or the application for leave must be within the jurisdiction under the particular state or territory legislation. So have a look at the arrangement as well as to whether or not it's going to be a short period, or whether it is like if it's a secondment, or whether there is some sort of permanent appointment to that. Unfortunately, it's one of those things that you'd have to take each circumstance as it comes. But bear in mind that previous service with a related company overseas has been determined by the courts here as being part of total service for the purposes of long service leave.
Okay, well that sounds a bit complicated. So that's at the end of the questions that we have prepared for you. If you're happy to stay on the line, Paul, I know we have had a lot of questions. We obviously cannot get to all of them because there are so many of them. But I would also like to ask you if you could just give us a bit of an update about the Victorian situation. There has been an act introduced or a bill introduced into Parliament there.
Yeah, not sure where this stands at the moment, other than it's had its second reading back in August. And I checked this morning actually before to see make sure that nothing had happened today or last week. Nothing has happened yet. There are 12 sitting days left to the end of the year, so and the last one's on the 14th of December, so may very well be one of those pieces of legislation they may attempt to put through. If it's going to be this year, it'll be the 14th of December. But I thought I'd summarise the bill for those people with operations or employees in Victoria. As I mentioned before, they're not attempting to introduce cashing out of long service leave, which is interesting in that sense. But one of the things that they are wanting to introduce in the bill is that to recognise unpaid parental leave for the purposes of continuity of service. In most jurisdictions at the moment, in fact, pretty much, well, actually in all jurisdictions at the moment, parental leave, unpaid parental leave wouldn't, it doesn't break service, but it doesn't count as service. So the Victorians are actually attempting to introduce an amendment whereby unpaid parental leave will count as service for the purposes of accruing long service leave. It already, I think, down there relates to paid parental leave. It's recognised, but unpaid parental leave isn't at the moment. The other one that's interesting, which actually is probably a question for next time, is that they're going to clarify the act down there to allow employees to take long service leave 1 day at a time. One of the things in which actually I don't know whether I mentioned, I don't think I did in the answer about being able to direct people to take long service leave, is that if it's a fair period of time, it can be broken up into blocks. That's where the employer is directing people to take long service leave. I guess the ambiguous or the uncertain issue is a lot of employees approach, and once again, particularly in relation to transition to retirement, is an employee with long service may want 1 day a week off for a period of, say, if someone's qualified for, say, 20 years or 15 years, that's 3 months. So there's 13 weeks, there's 65 working days, say, for 15 years. So that for the last, 14 months or so of their working career, they might want to work 4 days but get paid for 5. That's never really been questioned. Again, that hasn't been subject to judicial review. So it's interesting that the Victorians are actually allowing that to happen. I certainly know of employers who are allowing that to happen. I generally think it won't be an issue, but if the approach is by the employee to the employer couldn't direct. I certainly don't think that the employer could direct somebody to take 1 day at a time. But if the employee approaches it, then I don't think that the provisions of the sections of the Acts as they stand at the moment get in the way of that arrangement if it's the employee making the request, not the employer directing the employer to take leave. But the Victorians are actually going to the trouble of actually clarifying that, which would be helpful for people who want to take advantage of that arrangement in Victoria. The other thing that they're going to change, which may be important too, is that they want to allow employees to take long service leave after 7 years. So currently it's 10 years. So I guess what they're doing down there is that because someone's entitled to pro rata long service leave on termination after 7 years, regardless of the circumstance, they're probably figuring that, well, we'll make 7 years, you can take the leave as well whilst you're still employed. So they're bringing it in line with that. So yeah, there's a couple of other things that they're going to change, but they're more about who's exempt from the provisions of the Act. They're going to just clarify who's going to be exempt in terms of that. So and the other thing is that it's changing to working hours, which the bill provides a an option whereby the hours worked are averaged over the full period of continuous employment, and the employer will be entitled to the greater of the 3 averages. So there's currently 2. So they're introducing a third, which is usually, in fact, in a lot of jurisdictions, it's an average over the previous 12 months or 5 years, or it could be 3 years, depending on the jurisdiction. In Victoria, they're adding a third possibility, which is an averaging of the hours over the total period of the employment, whichever is the greater. So certainly you will be advised of any changes that happen. I'm not sure as to whether or not what opposition that will meet in the down there, but it's certainly gone past the second reading speech. So it's certainly now at a later stage of going through the parliamentary process down there.
Thanks, Paul. Thanks for explaining that. Now, as I mentioned, we have had a lot of questions. If you were able to just perhaps select a couple of them, given that we've really not got that much time left, and just perhaps give a bit of an overview, a bit of a flavour.
Well, yeah, I've done quite a few webinars, and I've never had so many questions on a subject in any of those webinars. Long service leave always never fails to disappoint as an advisor. There's always plenty of questions to be asked. Some of them I think are probably covered in, for example, is about long service leave for casual staff. Well, the answer is yes. I don't know any jurisdiction that actually disqualifies casuals from an entitlement to long service leave. Casuals certainly are entitled to it, provided that they meet that termination and re-engagement period that I mentioned in one of the answers to the questions before, the 2 months, 3 months that I was referring to before. So, provided that the casual meets those requirements and it's not a termination by the employee in some jurisdictions, then the casual would continue. The other thing too that was an issue that was once again determined by the New South Wales Commission about casuals who are kept on the books. They may not be working, but they're on the books. You've got to be careful in that if, as the employer, if you leave somebody on the books, you're more than likely, okay, they're probably not, it's not service, but it's not going to break the previous service. So if you've got somebody on the books, chances are you will more than likely be liable for all of the leave that they work because they actually haven't been terminated. It seems as that if you want the continuity to be broken with a casual employee, you let them know that. So you either, particularly, obviously, all these things are best put in writing. But yes, say that it is, rather than just leave them on the books. I know a lot of places just do that. They because it's convenient. Obviously, there's less paperwork. But don't be surprised if that arrangement goes over a 5 or 10 year period that you may get a claim from a casual saying they're entitled to long service leave when you may think they're not. There's one here that's a reference to the Long Service Corporation. Yes, well, we're not unfortunately covering those because they're industry specific. It's one about bonuses. Bonuses generally are included. They're usually part of the averaging system for payment of wages. We didn't have any on how you actually pay people, which is probably, once again, another one for another time, but bonuses are certainly generally included. Bonuses and commissions are generally regarded as remuneration for the purposes of most of the legislation. So if someone is on a bonus, that's more than likely got to be included, depending on the jurisdiction. Some might define wage to mean just that, may not make reference to it. But once again, check the state or territory long service leave legislation. Quite a few are specifically asking about specific states about when does pro rata apply. Well, yes, the answer to that is that does vary depending on the jurisdiction. The lowest is New South Wales, which is 5 years. There's a lot that is 7 now. In fact, probably the majority is 7 now in terms of entitlement on termination for pro rata. So yes, it's most of the others are probably more specific. There's one here about do people accrue annual leave on long service leave? The answer to that is yes. And you accrue long service leave while on long service leave as well. So it's period of long service leave is counted as service for the purposes of the National Employment Standard as well, because it's a authorised period of paid leave under a statute. So annual leave would certainly accrue, as would personal carers leave. as well. So those entitlements would certainly count. So I might leave it there for the moment. We're getting a bit over time, I think.
Okay, thank you, Paul. Well, as I think I mentioned at the beginning of this webinar, we would just perhaps take a poll because we're interested in engaging or interested in attending another webinar, further expanding on this topic, long service leave part 2. And that would probably be in early next year. So, okay, thank you. Now, can I also remind you, obviously we weren't able to answer a lot of questions today. We did have a lot coming in. So can I remind you that if you have the level of subscription to HR Advance, that you can contact our workplace advice line and they will actually help you with your questions on long service leave, or in fact any of your other HR questions. So if you're a premium and I'm can't think of the other level off the top of my head, if you have that level of subscription, you certainly have got that available to you. Well, I hope you found today's session useful. Please feel free to drop us a line at customerservice@hradvance.com.au, and if you have any follow-up questions, and also make sure you visit HR Advance, hradvance.com.au, and we can help you with the practical management of your HR work. If you want to revisit today's presentation, an archive will be published on our YouTube channel to watch and listen to at your leisure, and of course the URL will be included in our follow-up email, which you should receive shortly. Keep an eye on your newsletter for details of our webinar for next month, and I hope you have a lovely day. Thanks for listening.
Thanks for listening, everyone.